All right, everyone. Good morning. Good morning. All right, how's everyone doing today? Good. Okay, my name is Josh Blackman. I'll be your mock professor today. So first of all, welcome to law school. You've made it. You've all come from a lot of different places, with a lot of different backgrounds, a lot of different interests, and I'm personally very happy you chose South Texas, and we are very honored to have you here. I want to especially welcome you to this orientation, which I think is a very good first taste of what you'll get on Monday. Yeah, the orientation is a very short time away from class, so hopefully you can glean a lot. Have you found it helpful so far? You'll learn about writing, you'll learn about the note-taking process, you'll learn about the law school academic process, you'll learn about all the administrative things you have to deal with. I guess you've got all that done? Okay, good. So the purpose of our class today is not to teach you about property. Oh. It's not to teach you about foxes, I promise. We will not go on a fox hunt later. I don't care if you can hunt foxes. I don't even want to know what a fox hunt looks like. The purpose of our class today is to simulate for you how your class will look on Monday. Okay? I don't have any of your names. I don't want to know your name. So don't be afraid if you say something wrong. I probably won't ever remember you even did it. So this is a time for you to experiment, figure things out, and try to get your own bearings. Because I often describe the first year of law school as something of a marathon, full of sprints, right? So usually you run a marathon at a kind of a slow pace to get you through. Law school will be a series of sprints that combine to form a marathon. It's going to be a lot of work. Depending what you did in undergraduate before, you probably never had this much homework before. I had the same experience. You probably have never been forced to read so much in such a short time and be expected to have such a mastery of it. Okay? What's also going to make your life difficult is that you probably have 4 or 5 different professors, and they're probably all going to handle class differently, right? So you may have heard of something called the Socratic method. What's the Socratic method? This is where professors will make you stand up and answer questions until you can't answer questions anymore. Some professors do this, some professors don't. Some professors will just lecture for 90 minutes straight. Some will ask a question to each student. Some will ask questions only of one student. You're going to need to be agile and figure out how different professors approach law differently. And within a given day, you need to deal with 3 different styles of teaching, which is not always easy. Okay? Also, you're going to have to learn new language. What do I mean by that? If you read this opinion and you were confused, don't worry. You're supposed to be confused. I deliberately chose the case from 1805 because I wanted to give you a flavor of how law is written. Now, you will probably have some modern-day opinions, which are a little bit easier to read, but unfortunately, in your first year of law school in torts or contracts, you're going to have a lot of these old cases with stuff from the 1700s and the 1800s, even cases from jolly old England. And it's going to be written in a language that you're not going to understand. And that's fine. I don't expect you to understand everything. But what I want to show you is how do you approach something where the words make no sense, where you read a sentence and you recognize individual words, but the words together make absolutely no meaning to you whatsoever. So that's one of my other goals for today. Also, I want to teach you the basic reasonings of how court decisions work. What is a majority opinion? What is a dissenting opinion? How do you find a holding of the case? How do you separate the facts? How do you separate the analysis? These are the exact questions which you'll need to know in class Monday and on your exam and thereafter. Okay. Also, I want you to become comfortable. The people in this class you'll be with for the next 3 years. Get to know them. Become friends with them. Because the bar, as we call it, not the drinking bar, but the legal bar, is a fairly close-knit, small community. You'd be surprised how often the people you sit next to your first year of law school become your best friend. And then maybe one day they help you find a job or get a case or do something. Or maybe you need an expert in a certain field. Say, oh yeah, I sat with this kid in torts, and you'll remember that from years later. Okay? So be very tuned in to who your colleagues. Build your reputation, right? Also, your professors are here for you, and I mean that in every sense. We don't get paid extras to do things like this orientation. We do this because we want to help you. Try to get to know your professors. It's tough in a section of 70, 80, 90 people to actually stand out. Okay? So how do you stand out? Well, the easiest way is answer questions correctly. We remember that kind of stuff. So we actually don't always remember, if someone messes up, kind of just forget about them, maybe mark it down. But if someone gives a standout answer, you make a note of that. And they give another excellent answer. You kind of remember that. And if you go to the professor's office hours, so, oh yeah, there's a student who sat in the corner over there, gave me all those good answers. So you start building relationships. I can't stress how important this is. Even going a couple times during the semester to office hours means a professor knows who you are. I would have students who would come to me the week before the exam, and I really had no idea what they were. I mean, I knew their name, I knew where they sat, but I knew nothing else about them. So try to actually build a rapport with your professors. Also, try to think about what do you want to do. You don't need to decide this right away. In fact, I would encourage you not to make any firm decisions your first year. You probably don't know enough. But expose yourself to as many different areas of the law as you can. Maybe this interests you. Maybe that interests you. Even if you come to law school set on doing something, you want to do oil and gas, which probably like half people in this room, open your eyes and just try and look at different things. I think you'll find there's a lot of opportunities for you to learn and develop and thrive and flourish. Okay? All right, any questions before I get started? Anything what's on your mind? And again, I don't have any of your names. I will not mark down any stupid questions you ask. I will not. There are no stupid questions, but you can ask me anything. If you want to talk to me after class, you can do that also. And I actually have a special treat for you in that bag. It was my birthday on Wednesday, and I have a very nice birthday cake, which I will take out after class is over. I just got bowls and everything. But so that will be your incentive not to make me mad. So you will get the cake assuming everything goes according to plan. I would do it now, but it'd be too messy to pass around. I considered it, but I'll do it after class. See, it's usually actually for 2 years in a row, the first day of class was on my birthday, and this year happens to be like a couple days later, so I will carry the tradition on. Okay, let's get started. Any other questions? All right, so the case I assigned for you, Pierson v. Post. This is a famous case. Okay, why is it famous? Because every single property law student in the last 125 years has read this. I am not exaggerating. Go to any of your parents or aunts or uncles who are lawyers and ask them about the Fox case. Oh yeah, the Fox case. This case will be burned into your retina. Okay, whenever you say, "What does the Fox say?" you'll think of this case. This is the canonical property case. Now, you're not going to be taking property till the spring. You might have me in the spring. I don't know, depending on how your schedules work out. But you will do this case, I promise. So you at least will have one small leg or paw, I suppose, up on the other students who haven't seen this case before. So first of all, let's start at an even basic level, right? Why are you reading cases, right? Why did I make you? I didn't make you buy a book yet, but why did other people make you buy these nice, thick books that cost almost $200 that are filled with nothing but these old cases from the 1800s? Because this is what our legal system is built on. Our legal system is built on cases. Now we all think, oh, what about statutes and regulations? Those are fairly modern. And by modern, I mean the last 150 years or so. For most of our legal system, which traces back to England, who made law were cases. Judges would consider a dispute between, X and Y, right? Two people have an argument, they have a conflict, and they say, I want the fox. No, I want the fox. Who gets to keep the fox? Okay. Two people have a contract. One person performs, one person doesn't perform. What happens? Right? Someone trespasses into someone else's property. They want to seek some damages from that. Long before we had statutes and laws, we had judges deciding cases. And they developed something called the common law. The common law. What is this common law? You'll become familiar with it very soon. The common law roughly means judge-made law. And I don't mean that the judge is making it up. I mean that over the course of years, decades, and centuries, judges develop legal doctrines to resolve disputes. So you'll notice in this case about the foxes, they mention all these people. Justinian and Barbarac and Pufendorf. No, this is not a Harry Potter thing. Everyone thinks that, right? These were writers in the law who wrote these big, thick books discussing, okay, when you have two people fighting over an animal, here's how you decide who resolves their dispute. So what these decisions did was they actually developed the law. And they didn't develop the law by broad principles. They looked to specific cases, right? So when you had Mr. Pierson and Mr. Post who came to the court in New York, right, in 1805, they had to deal with something. They had to decide who gets to get the fox. Now, I'll give you some background. In case you weren't sure, this case wasn't really about the foxes. These guys hated each other, okay? These were long-standing rivals who really didn't like each other. And the actual fox didn't matter, just the hunter was really pissed off that this other guy came in and took his fox, right? So the value of the fox is only dollars, whatever it is. But they were fighting for principle, which you'll find is most lawsuits eventually boil down to. It was a principle of the matter, right? If you ever have a client and they say it's a principle of the matter, say stop. Just let's talk about this. But anyway, they appealed it. So first of all, I'm going to give you a trick that you'll use in every single case, right? Pierson v. Post. Did you know that the order in which their names are listed signifies who is appealing and who won in the court below? Ah, right. So we actually have a situation, right, where there was a lower court judgment, right? So we see here, this cause comes before us on a return to certiorari directed to one of the justices of Queen County. Let me translate that a little bit for you. This case came from Queens, Long Island in particular. Anyone from New York? I'm from New York. No one from New York? Wow. Okay. Well, I'm from Staten Island. I don't advertise that much, but I am. So this case actually came from hunting on the beaches of Long Island, if that means anything to you, which it probably doesn't. It's like Galveston, but with a lot more sand, okay? So there was a lower court decision, okay? The lower court made a decision on this case, okay? So whose name comes first? Okay, Pierson, right? Whose name comes second? Post, okay? Let's try to figure out who our people are. So I don't have your name, so ma'am in the back? Anne? Anna, thank you. Who's Pierson? Which one's Pierson? What did he do? Let's discuss. What did Pierson do? Well, you have a 50-50 chance. Which one was he?
Was he the one that was, he was the one chasing the fox, wasn't he?
He wasn't the hunter. Which, he was what?
The one that shot the fox.
He was the jerk. That's how you remember it, right? Pierson was the jerk. Okay, and then obviously Post was the hunter, right? Okay, so this is one thing. The first question the professor will ask: who are the parties, right? First thing, the first 3 lines of the damn opinion. Who are the parties, right? So Pierson was the jerk. Post was the hunter. Post was the guy who had the hounds and the dogs and was chasing in regal stature the foxes. This is a big aristocratic event back then. This was a big deal. This was like polo or some sort of very classy event. Okay, so Post was the hunter, Pierson was the jerk. Okay. All right. So now, ma'am, what's your name? Pam. Okay, Pam. What's the significance that Pierson's name comes first here? Do you know? But why do you think his name comes first? Exactly. Exactly. So originally, who sued whom, right? In the trial court, the hunter sued the jerk, right? The hunter sued the jerk. I'm gonna use hunter and jerk because it's a lot easier because they're both P and they get confusing. I get confused every year, right? So the hunter sued the jerk. And Pam, so who won in the lower court? The hunter. Yes, right. So the hunter won. Exactly. So now we're at the Supreme Court of New York, right? And there's an appeal. So, sir, what's your name? Jonathan. Jonathan. So who filed the appeal to the Supreme Court? Pierson, who's the jerk, right? Right. So now the jerk comes first. So now, when you ever have a case, even if you forgot to facts, right, you can at least figure out who's appealing. So if we know that Pierson's appealing, he lost the court. Okay, there's your freebie, right? So if the professor asks who lost in the lower court, even if you have no idea, if the jerk's name comes first, that means he lost. The reason why he's appealing is he had a judgment that wasn't to his liking. Exactly. It flips. Exactly right. In the trial court, the first court, it would have been Post versus Pierson. And then at appeal, it flips around. and I'll warp your mind, had this gone to the U.S. Supreme Court, it would have flipped around again. It would have been Post v. Pearson. Because Post lost this one, they gave it to the jerk, and he, exactly. So pay attention to which name comes first. This will buy you like maybe one question this semester. You're like, hey, thanks, Blackman. Right, so there's your freebie, okay? I promise. So one of you will use this. Okay, good.
Is New York the only one that calls their appeals the Supreme Court?
Oh, okay. So actually, it's an interesting question. So at the time, the highest court in New York was called the New York Supreme Court. Okay? We have the Texas Supreme Court. At the time, it's called the New York Supreme Court. That's the highest court in the state. But to confuse you, perhaps not so much, now, the highest court in New York is called the New York Court of Appeals. And to really mess you up, the trial court in New York is called the New York Supreme Court. Anyone ever see Law and Order? Right. Ever seen Law and Order? It says New York Supreme Court. Do you ever wonder why? Yeah. In New York, the trial court, the basic court, is called the Supreme Court. You don't need to know that. Don't worry about that. But yes, the highest court is there. Okay? All right. Everyone okay with that so far? I'm going line by line. When you read a case, you have to digest stuff very quickly. Okay. What's this 3 Canes 175? So what's your name? Marco, do you have any idea what that is?
The title of the case.
What do you mean the title of the case? Good. Okay, yeah, that's right. This is what we call a citation. I don't know if they mentioned this in legal writing, but before the internet, there were things called books, right? And all of the cases were reported or written down in these books. And each book was a series. So, for example, this is a series called Canes. Why was it called Canes? That was the name of the reporter. He actually would sit down and write all the opinions into a book. That was his name. Okay? So there's 2 numbers, right? The first is 3. And remember this because you're going to have to do this later. The number to the left of the word means the volume. So this is the 3rd volume, the 3rd edition of Canes. So there was, Canes 1, Canes 2, Canes 3. All right? Marco, what do you think 175 means? Exactly. The page number. So that means if I want to go find Pierson v. Post without the internet, right? I will go to I would find the Canes volumes. I pick out book number 3. I turn to page 175. Okay, everyone get that? All right. You're going to have to do this in legal writing, not with Canes, because I don't even think we have a copy of that in this library. Probably not. But with other books which are similarly fashioned. Did anyone ever notice this? The star 175, the star 177. Anyone want to guess what that is? So what's your name?
Walter?
Walter, what do you think those star numbers are?
I don't know, but it might be related to the page number.
Exactly right. The stars are actually what's called the page numbers, or pagination, if you will. I realize I'm being very simple, but when you read a court opinion, it's like here, 175, 177. Believe it or not, even though this book, 3 Canes, was published 215 years ago, whatever, the page numbers he chose, we still use. So even though this is on a PDF that's 6 pages long, they actually reproduce the actual original page numbers. So say you wanted to find, this section, right here, you would actually turn to page 178 of that book. You will soon learn something called the Blue Book. Has anyone ever heard of the Blue Book? Oh, some people are nodding. The Blue Book is a system of citations. You might have used MLA or APA in college, right? We have our own book, and it's evil. It's a horrible book. Don't tell Professor Sparling I said that. I don't like it. You can tell him. That's fine. But I'm not a fan of it. But you're going to have to learn it anyway. It sucks, but you have to learn it. And there are very precise methods of citation, okay? And you will learn in great detail how to cite something. If you want to quote from Pearson v. Post, you will need to use that 3 Canes 175 and then tell you what page number it's on. You need to provide all that information, okay? All right. Everyone with me so far? Okay. Let's while I'm on the topic citations, I'll show you these. Did anyone notice these? Right? It's the same thing, but with a slightly different format, and it's in Latin. But you'll get used to this, right? Lib, like Libra, book, the same thing as volume, right? So these are Justinian's, and Justinian was a ruler, and he wrote down all these laws. So it's Book 2, Title 1, Section 13. These are all different ways of explaining to you where to find information. Right? Before Google, we had very detailed citation systems to get you to the right answer. All right, everyone get that? You'll do lots of citations, but at least you'll be exposed to it. Professor Darling is a wonderful teacher. He will explain to you how to use the Blue Book and how to do research. But now you at least have some clue of how this stuff works. Okay? All right, so now, by the way, we spent 20 minutes in the first case. How long did it... I bet when you first got this assignment, you thought, oh man, it's 6 pages, I agree that one in 20 minutes, right? Anyone do it in less than an hour? 2 hours? 3? Yeah, about my first time, probably 3 hours, right? So that's your other guide, right? When you get your syllabus, which you should have already received, and your first day of class, you have 15 or 20 pages of reading, give yourself like 8 hours. I'm not exaggerating. If this 6-page thing took you 2-3 hours, triple that for your first stage reading. Okay, and that's for each class. And you will quickly see that law school becomes a full-time job. It's going to be a 40-hour-a-week commitment easily, right? There's no shortcutting it. Okay. All right. So now you're asking yourself, okay, Blackman, I read the first 5 lines of the case. I already wasted 30 minutes. Okay. What comes next? Okay. Now you start reading the case. And have they given you a session on outlining and taking notes? They've given you some. Okay. So here's my own perspective is that the process of outlining varies for everyone. Everyone does things differently. Everyone learns differently. There's heresy, but I don't think there's any one right way of outlining. I'm sure they will tell you, here's how you have to do it, and I would encourage you to start that way because you don't know anything else. But you might find that different things work better for you. Okay. So there are certain things which you can't shortcut. You have to read it. Right? There are these things called commercial outlines. If you haven't heard of them, you will soon. Okay, these aren't substitutes. Okay. Now, some people might say, oh, these are written by, people who don't know what they're talking about. Generally, they're actually written by law professors. They just don't admit it. A lot of these commercial outline books are written by law professors. And I think in some cases they might provide a decent supplement, addition to the textbook. But you have to read, and you have to pay attention in class. Okay. Why? Because your professor will write his exam or her exam based on what he or she teaches, not what's in your book. Okay? This is the biggest mistake first in law school. They sit there and they study this other commercial outline, this other, horn book, whatever, right? And then, whoops, the thing the professor tests on is not in there. You're fried. So, I'm not going to lie to you and tell them they're unhelpful. That's what people told me, which was wrong. They can be helpful, but as a supplement, okay? And I know as I'm telling you this, a lot of you will ignore this because we know when you're reading a commercial outline. Like, I can actually see the book on your desk. I occasionally have students brazen enough to actually read from it in class, and they're usually wrong. So read the cases. It gets daunting, okay? So that's when you can't shortcut, okay? The next step is how to actually write down the notes of your case. And I'm sure they've given you different things. If you want to write them by hand, if you want to type them, if you want to use a tablet, I don't really care how you do it. But at bare minimum, you should be able to answer a few questions, right? Right? Who are the parties? Right? That was the first question I asked you. Who's Pierson and who's Post, right? And that trips some of you up, right? Because you forget. You need to make clear in your notes who it is. That way I can say, oh yeah, Pierson's the jerk, right? And Post was the hunter. Boom, done. Okay? What are the facts of the case? In case you didn't notice in this one, the facts weren't listed up front in a nice section called facts. Mm-hmm. Right, yeah. They were kind of buried throughout. And by the time you got to the end, I was like, oh, it was a fox hunt. That's what happened, right? You need to be in your notes listing what happened. Post was hunting the fox. Pierson was a jerk, in different words, and intercepted the fox. They sued each other. Okay, now the facts. The next one is something called the procedural posture. What's this procedural posture? It's not like a silly posturepedic bed, right? The procedural posture is what happened in the lower court, right? I think almost every case you'll read this year will be an appellate decision. I don't think you will read a single trial court decision, so you have to assume that everything you're reading started off in some lower court and then was appealed to some other higher court, maybe a state Supreme Court or the United States Supreme Court or whatever. It doesn't really matter. What happened below? That's your procedural posture. And again, in this case, you get one frickin' sentence. That's it. Actually, you get one sentence and the ordering of their names. So if the professor asks you, Mr. So-and-so, or Mrs. So-and-so, what happened in the lower court? You can say, okay, post the hunter sued the jerk, right? And the hunter won. Then the jerk filed an appeal to the New York Supreme Court. Done. A+ answer, right? Did any of you get that from the opinion? Maybe, maybe not. But that's why you have to really digest each line, right? It gets easier, right? The first month will be the worst, then it gets a little bit better. Okay. So after, yes, ma'am.
Yeah, what's the difference between procedural posture and procedural history?
Same thing. Oh, and here's the beauty. People will call different things. People use different words for the same thing. And I thank you for asking that, right? Is that what they call procedural history? They can say what's the posture of the case, is it leaning back, whatever, right? What's procedural posture? What's the history? Or just what happened below? That's one way of asking it. What happened in the lower court? That's why I mentioned professors have different ways of teaching, and you need to accommodate their style, as horrible as that is, right? It'd be too easy for us to coordinate and teach you the same way. That'd be way too easy for you. Although in truth, you will deal with lots of different people in your lives, and this is a nice, unfortunate preview. You got your party, right? You got your facts. You got the procedural posture, right? Okay. Next, what's the analysis, right? How did the court reach its conclusion? And we'll talk about this a little bit more in a few minutes, but they look to some of these ancient writers. They look to some old British cases. They look to fairness and efficiency. Hunters, right? Break down the analysis of each judge, right? There's a majority opinion, there's a dissenting opinion. Break down the analysis, okay? Once you get all this, you need to write something called the holding. Holding, right? What does the court hold? What has the court decided? And it's not enough to say, and this is the wrong answer, reverse, right? The answer is not the Supreme Court reverses or overturns the lower court. That's the wrong, I mean, it's not wrong, but it's a totally incomplete answer. The holding is, what is the rule of law of this case, right? These two judges were arguing over something very strenuously. The majority won. Okay, what was the majority's opinion? How do you summarize the entire case into like one or maybe two sentences? Here, you can do it in one. I'm not kidding you. Your professor will ask you, what's the holding in like one sentence? Yes, sir.
Whether merely chasing and gives you rights to own it or not.
Does it? Well, you just posed a question, right? So what was the holding?
The holding is that it does not.
Okay, good. Just give me the full sentence. So, yeah, this is what you're going to get next week. You're on the right track.
The holding in the case is that merely chasing an animal does not constitute owning.
Exactly. Right. That's the perfect answer, right? You got to be able. Thank you, sir. You got to be able to distill the entire case into one sentence, like he just did. Right. And again, there's going to be a temptation to just read it from a commercial outline. You're really selling yourself short if you do that, because you're depriving yourself of the skill of putting together. That wasn't easy, right? That especially on the spot. Right? That's why you need to write it down in advance. Ah. So you see, if he had, and I'm not putting him on the spot, but if any of you had wrote down in advance that one sentence, professor says, what's the holding? Read it. Perfect. Done. Right? And the professor leaves you alone.
So in an actual class, and we had say an outline.
Yeah.
And you would ask me that. I could just look. I mean, separately look at my outline.
Yeah. You might not want to read it verbatim, but if it's right there, you can refresh your memory pretty quickly. Yeah. More so, the act of writing makes you remember stuff. And I don't, the studies for writing by hand, typing, I really don't care. I learn better by typing. I've actually lost the ability to write by hand. It's actually sad. writing a greeting card hurts. I've given up on pens. I don't ever write anything by hand. But I don't care how you write it. The actual act of moving fingers in whatever manner, right, will rest it. So, was your hand up?
I was just gonna give my answer.
Okay, that's fine. What's your holding? How would you phrase it?
Physical occupancy within the limits of property, wounding, or tagged instruments is the only way to define possession in a common area.
Yeah. Okay. So that added some other layers, which we'll talk about in a minute. That the traps and the nets and other things. But either holding is fine, right? So that's what you have to look at. Okay. So let's see. You got your who are your parties? What are the facts? What's the history of the case? What's the analysis? What's the holding, right? I just gave you 5 things. Maybe they gave you 6 or 7. I don't know how many things they said, but that's the general gist. Yes, ma'am.
So would you say that it was reversed before you list the rule of law in the holding?
I wouldn't even mention that. We don't really care about the justice of Queens. It's just funny. The way the common law works is the most interesting element is what is the rule of law, right? So say if there's a dispute the next year in Brooklyn somewhere, and these 2 people are chasing, I don't know, a wolf, and the exact same thing happens, the court will say, okay, citing Pierson v. Post, you need to actually capture the animal to have ownership. You, hunter, didn't capture it. Therefore, the wolf goes to the jury. Right? Everyone get that? That's what these cases are trying to accomplish. They're trying to find what's the rule of law. That way, so the lower court doesn't mess it up next time. That way, the lower court doesn't need to look at Justinian and Barbarac and Fleda and Blackstone, all these old scholars who aren't really relevant. One historical note, if you like history, what's significant about 1805 New York? Specifically with our legal system. All right. What year was our independence? What year was our Constitution drafted? 7. Oh, man. Constitution, 1787, right? Ratified 1789. Okay? What do you think happened to all the British law we relied on following the Declaration of Independence and our Constitution?
We adopted the
Exact opposite. We got rid of them. We said to those redcoats, scram, get lost. And not only did we kick the redcoats out, we kicked out their law. So effectively, all the English law, the statutory law from the Crown that commanded us, we got rid of. So in 1805, they were pretty much writing on a blank slate. There's this one sentence in the opinion. Right. Little satisfactory aid can be derived from the English reporters. Right? Why? Okay? Because it was decided on a little bigger. All these old cases, these English cases, were decided in English statutes, which we no longer respected. So here, the court was deciding on a clean slate. Like, we don't listen to those British cases. We don't respect their law anymore. So what did they do? Because they couldn't look at the British laws, they turned to other authorities. Okay? Who are these other authorities? These are all these philosophers. Now, anyone studying natural law in college, don't ever hear the name Pufendorf, Barbarac, Justinian, Fleda, Blackstone. Okay, you'll learn these names this year, especially if you have my class, right? These are all these natural writers who wrote these big books discussing different laws. So they said, we can't look at the English judges. We'll look at these older guys who we haven't rejected yet. So that's just one small footnote about the time period. Okay. So, no questions so far? Very good. All right, so at the outset, we have 2 opinions. Okay? So it's Tompkins, comma, J. All right, ma'am, what's your name? Sophia? Sophia, what does comma J mean?
Comma J?
Yeah.
J would be his first name.
Okay, that's what I thought too, right? For the first month of law school, I thought every single judge had the first initial J. And I'm not saying this to embarrass you. I was like, wow, all these judges have the first initial J. It means judge. I tell you this because I made that same mistake for the first month of law school. I was like, holy cow, what are all these J judges? What's like the coincidence? And then it hit me like, oh, it's judge. Okay, And so what's your name? Marco? Markham. What does JJ mean? Oh. Okay, that's what I thought too. You guys you're on my wavelength. It means judges, plural. So if they list a couple names, comma JJ, it means judges, plural.
Let me ask you a question, though. Who else would be giving it?
Ah. Well, probably no one else. But what difference does that make? Well, a magistrate would probably also take the initial judge. Now, okay, one more. Yellow shirt, what's your name? Andrew. What does CJ mean? Chief Judge or Chief Justice, yes. Okay. So, the little things that they don't teach you in law school. I labored on that impression for at least a month of law school, where I thought his first initial was J. So you're totally reasonable. Okay. So we know that Tompkins, so this is Judge Tompkins, and he delivered the opinion of the court, okay? What's your name? Jacqueline. What does that mean, the opinion of the court?
The reason that the majority,
Good. Use this word majority. What does that mean in this context, at least?
like what do they find?
What do you mean? Who's the majority?
Oh, on the court, how many? The majority of the people that decided in favor of the post.
Yes. Okay. Good. All right. So here's how an appellate court works. There's almost always an odd number of judges. Almost always. 3, 5, 7, 9. For example, our U.S. Supreme Court has 9 justices. Why? Ma'am, what's your name in the bailiff shirt? What's your name? Yeah. Jennifer. Why do you think there's always an odd number of judges on an appellate court? So there's no ties, right? Okay. So how is a majority calculated, Jennifer, when you have, say, 9 judges? What's a majority? 5 or more, right? When you have 9 judges, you need 5 or more. When you have 3 judges, 2 will do it, okay? We actually don't know from the opinion, I could tell you, but you don't really care, how many judges on the New York Supreme Court. I'm guessing there were 5 or 7. It doesn't really matter. But when we say that Tompkins delivered the majority opinion, when Tompkins delivered the opinion of the court, that means it was the majority opinion where at least, say, 3 of the 5 judges agreed. Yes, sir?
Weird question. Does a judge have to vote? Can they abstain from voting where it doesn't end up as an odd number? Is that something if they can't make
where
they decide?
Well, you might study a case to see where that happens, but it's very rare. It's very rare for a judge to just not vote because that's his job. His job is to cast a vote. There might be cases where a judge recuses. What does it mean to recuse? Say there's a conflict of interest. Say like Pierson was his brother or something, right? He would probably have to step down and say, I can't decide. In that case, ties can arise. Let's try another hand somewhere. Yes, ma'am?
So in an appellate court, it's the judges that decide, not like another jury.
Okay, exactly. There are no juries on appeal, right? In the trial court, you have a judge and you maybe have a jury. In an appellate court, it's a very different scenario. You only have 3, 5, 7, 9 judges, and all the evidence that exists was evidence at the trial. There's nothing new being introduced. Let me ask, so what's your name? Joseph, what's the point of an appellate court? Why? Why is there an appeal? Why do parties appeal a case? But more so that they were wrong, why would a party appeal? What's the argument? Think about it. If you're writing an appeal, right, what do you put on the first page of your brief, right? Say you're the hunter, right? I'm sorry, say you're the jerk, right? And you lost in the lower court, and you follow your appeal. What in your appellate brief? You're representing the jerk. Why should a lower court care what your position is?
Why should the lower court?
I mean, why should the Court of Appeals care what happened below? Now, what's your name?
Michelle.
Michelle, why should a lower court care what happened below? What's the first thing you write on your appellate brief telling the Supreme Court to do something else?
Lower court screwed up.
they made a mistake, right? The purpose of an appellate court is to correct errors, is to fix mistakes. The jerk would argue, hey, Supreme Court, the lower court made a mistake. They messed up. They gave it to the hunter, but hey, look at me. I got the fox. I caught him. Right? So every appellate decision, you have two people, right? You have Pierson, who's appealing, the jerk, saying, hey, you guys messed up, right? And what's Post saying? Now, what's your name? Yvette? What's Post saying about the lower court decision? Yeah, he's like, no. Correct. Everything he did was right. Listen to them. Listen to them. Yes, sir.
So can you only then appeal questions of law, but not questions of fact?
Okay. So I wasn't going to go there, but now I'll go there, right? So he mentioned two different concepts, right? A question of law and question of fact, right? So let's say, for example, the lower court messed up. Let's say the jerk didn't actually catch it, right? Let's say the hunter actually caught it. Let's say the jerk filed a lie. He just lied about it. Okay? And say for whatever and believed him. Okay? Then the hunter could say, hey, they messed up the facts. I'm going to, even if the law works this way, I got it first, right? So if a lower court messes up the facts, an appellate court can correct that. All right? I'll get to your question in a second. But the second question is a question of law, right? The lower court held, as a matter of law, that the hunter gets it, right? That the person who puts all the labor and energy into the hunt gets to keep it. What the jerk argues is, you guys messed up the law. That's not what the law says. The law says whoever captures it first keeps it. So most of the appeals you study will be a question of law and appeal. I think it'll be fairly rare that anyone appeals facts because generally the facts are set. You don't mess with facts. Yes, sir. What's your name?
Doesn't the jury decide the fact?
Ah, that's right. Well, no. Close, but no. So generally speaking, juries decide questions of law, right? They decide guilt or innocence. Okay? They can also consider facts, but they can still make mistakes. So say if a jury egregiously makes a mistake, make a terrible mistake by the facts, a higher court can reverse them. Yes, ma'am.
So yesterday, Dr. Sparman mentioned that as long as there had been an objection.
Ah, good. So, what's an objection?
I presume during the course of the trial, the attorney, just
Okay.
mentions that it's not their issue.
Okay, good. So here's an important practice, which we're glad Professor Sparling mentioned to you yesterday. When you are in court, or you're filing briefs, and the other side makes a bad argument, and then the judge accepts it, you have to say one word. I object. That's actually two words. Objection. I ruined my own. Whatever. Objection, right? Two words. Whatever. You have to put yourself on record as objecting to the court's ruling. Okay? So say the lower court said, okay, you know what? Let's give it to the hunter, right? Let's give it to the hunter, not the jerk. If you're the lawyer for the jerk, you say, Your Honor, I object to that. I think as a matter of law, the jerk should get it. Okay? You've now done something very important. You have preserved your appeal. If they want to make jelly or jam, you preserve it, right? What does it mean to preserve your appeal? By raising your hand and saying, I object, you've now allowed yourself to appeal. And what's your name?
Kathy?
Kathy. Kathy, what happens if you sit on your hands and you forget to object? You lose it. You waive it. So imagine that, you lawyers. You got to pay attention, right? If you fail to object when you're supposed to, you can't file an appeal. You can't file a damn thing. The other lawyer will say that you waived your objection. You sat on it. And very often, you have a split second to object. Now, if you're a prepared lawyer, which I hope all of you are, you should know in advance when these things come up, right? You should know, okay, the biggest issue in this case, right, is who gets the hunter or the juror. So you should be ready. Okay, so when the judge makes this ruling, I'm just going to raise my hand and object, and that way I'm covered, right? But that doesn't always happen. Perhaps the judge might come out of left field and say something. The other lawyer might say something else. You need to object. Don't sit on your hands. Yes, sir.
Do you actually need to get a ruling on your objection by the judge?
He will overrule it. It doesn't matter. You say, Your Honor, I object. He says, objection overruled. Let's move on. But you put on record that you oppose it. And that's all you need. You don't even need the judge to rule in your favor, really. I mean, you hope he does, right? I mean, it'll sometimes happen where your other lawyer will say something stupid or ask an inappropriate question, and you object, and the judge will go, objection sustained. Please ask your question differently, or please make a different argument, or please withdraw that document, right? You'll learn that a lot of these things are usually done in advance, right? So you'll probably just call it a motion in limine. You know what that is, right? Before the trial even starts, both parties will file different briefs saying, here are the issues we expect to come up. Let's on these in advance rather than the middle of the trial where everyone's running around. That way you can get an advance ruling. And if the judge rules against you, you say, Your Honor, I object to these rulings. I renew my objection.
What did you say that was called?
A motion in limine. L-I-M-I-N-E. In limine. Yes, sir.
The briefs sent to the appeals court, are they limited to what's in the brief, or can they go beyond that and look at the meaning? Is all these cases of this writing part of the brief, or can the appeals court go beyond and say, well,
Okay.
they're not necessarily right on the brief, but the law is on the side?
Okay, so let me answer your question in two different ways. There's something called the record. Okay, when you are in a trial court, every piece of evidence that's submitted to the court is put into a record. I don't know whose binder this is, but it looks something like that, right? It's these huge binders with lots of paper, right? Once the trial is completed, the record is sealed. No new facts are allowed to be considered. Judges break this rule all the time, but they're not supposed to. When an appellate court's considering a decision, they can't Google stuff, right? They do it anyway, but they're not supposed to look outside the record. I'll give you an example that's actually quite egregious. Recently, there was a case involving a labor dispute where you had these workers in a slaughterhouse, right? And their job was to cut up chickens. Okay, not a glamorous job, but messy, real messy. And that's where this protective gear. And the workers alleged that they spent a lot of time with their break, like a 30-minute lunch break, taking this gear off, washing their hands, and getting all the chicken giblets off themselves. And then they can have their lunch, and they have to wash again and put all this gear back on, right? And they said that out of the 30-minute lunch break, this took like 10 or 15 minutes of the lunch break. Okay, this is what the parties alleged, and they said we want more overtime, whatever. Okay, there was a judge. His name is Richard Posner. You will learn about him soon. He's a very prominent judge. He decided, I don't believe it takes that to take on and put off the clothes. So what did he do? He bought the clothes, and he asked his law clerks, people not much older than you, to go in chambers and time with the stopwatch how long it takes them to put on the clothes and take them off. Okay? This is a no-no. Judges are not supposed to do this. Judges are not supposed to create evidence out of thin air. Okay? And what's the problem? First of all, his law clerks didn't have chicken giblets all over them. Okay? They didn't have to wash off all these chicken parts from their body. Okay? Second, if any of you have ever been in a slaughterhouse, there is only a few sinks. There is a line that forms, much like around the cake in a few minutes, right? There will be a line that forms in order to wash your hands. So the experiment was entirely bunk, right? I actually wrote an op-ed about this. It was a big deal. So judges break this rule all the time. But to answer your question, no. They're not supposed to go and Google and do little experiments and stuff. Judge Posner said he did to satisfy his curiosity, whatever. It was wrong, but that's it. Your second question, though, which was also a good one, are they allowed to cite all these opinions from these other judges and other writers? Yes. Okay. On questions of fact, this is his point, on questions of fact, you're stuck with the record, right? You can't add new facts. But on questions of law, you're fine. If you want to read this book or read that book, or cite this opinion, or cite that opinion, or cite this statute, that's fair game. You can do whatever legal research you want. And yes, it's very often the case where the lawyers write very bad briefs, none of you, I hope, and the judge will have to basically make the argument for them, and that happens fairly frequently. Okay, so let's talk a little bit about precedent. So you'll learn this in legal writing, but there are these two forms of precedent: binding and persuasive. Did you hear those terms before?
Yeah.
Good. Okay, so I'll refresh it briefly. Right? If you're in Texas, right, and someone goes to you and say, "Hey, here's a decision from New York," is a Texas judge required? No. That's merely called persuasive. Okay, what's the mean to be persuasive? Well, it gives some, evidence or some, reasoning that might be helpful, but you're not required to follow it. Now, if I walk into a Texas court and they start waving around an opinion from the Texas Supreme Court, what is that? Binding and persuasive?
Binding.
Yeah, you got to follow that. You don't have a choice. If I walk into a Texas court and I start waving an opinion from the U.S. Supreme Court, binding, yes, just as much. Perhaps they might not like it as much, but that will be a binding decision that a Texas court or any court in the United States will have to follow. Okay, my pocket. There's actually a clause in the Constitution, which I'll carry this around daily, which says that every judge in every state takes an oath to the Constitution. So, what's the supreme law of the land that all judges in the United States are bound by? Right here. Every judge is bound by this. So, what if I have a constitutional claim that conflicts with the Texas law? What happens? Constitution wins. Always wins. Hopefully. Okay? So everyone get that? Yes, sir.
There's a federal court of appeals. Does their law apply to the states?
All right. So let's talk about federal courts. Okay. I didn't know this either when I first started law school. Okay. So we have two different systems of courts, right? We have state courts and we have federal courts. All 50 states have their own court system. Texas, New York, New Jersey, whatever. Okay. But as well, the federal courts have it. And in every single state, federal courthouses. Okay. There are federal trial courts. They're called federal district courts. And there are federal courts of appeals. These are called the circuit courts of appeals. Okay. And the United States is actually divided up into 13 circuits, right? Texas is in what's called the Fifth Circuit. 5, easy to remember, right? And it's lumped together a couple states: Louisiana, Mississippi, and Texas. So any federal case that originates in Louisiana, Mississippi, or Texas goes to the Court of Appeals. They sit in New Orleans. That's where the court is held. Okay. To answer your question briefly, the federal precedent is pretty binding. Not entirely, but it's pretty binding. So if you're a Texas court, a Texas state court, and you look at a Fifth Circuit Court of Appeals decision, you probably should follow that. You don't have to, but you probably should. Unclear if the Texas Supreme Court has to. I've actually grappled with that question, but if you're a lower court, you should follow it. Why does any of this matter? Well, when you go writing an assignment from Professor Sparling, he will ask you to write a memo of some sort. And you're going to need to find case law that supports your position. And you're going to need to be good to find case law in the jurisdiction or in the area you are. Because if you start citing cases from, like Kalamazoo, Michigan, you're going to be in trouble. Okay? You need to find case law that's local to where you are. That's how precedents work. All right, questions? Are we up till 10 or 10:15? Okay, good. I'll let you out a little bit early so you have some cake also. It's a busy schedule there. That'd be pretty much jam-packed running from one thing to the next, right? Yeah, it's. Is there a social anything afterwards? Do they have anything scheduled? Two. That wasn't what I meant, but okay. You'll organize those yourselves, I guess. There's enough places nearby, as you'll learn. Okay. All right. Other questions before I move on? All right. So we have the actual case itself, okay, and I think we've gone over it enough. But by this point, what you should have gotten is like this. So you have these two guys, right? You have Post, who's the hunter. You have Pierson, who's the jerk. They don't like each other. Post is hunting a fox on the beach of Long Island. He has, the hounds, of imperial stature, right? He probably has the horn, and the entire outfit. Anyone ever seen fox hunting? it looks glamorous, so they start actually eating the foxes, or killing the foxes. But so they're chasing it, and he corners the fox. He corners him. At the last second, this jerk swoops in, kills the fox, and probably runs away and says, "Ha ha, na 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 na," right? Okay. So the court is then confronted with the dispute. Who gets the fox? And make the mistake, they're fighting over the hide, right? The fox is dead. The fox is not. It's not for a pet. They want the actual fur. So who gets the fox? So let me walk you maybe paragraph by paragraph just to help you read it. The first paragraph is just what's the question. The second one says who gets it. So what the court first does is they turn to what they call. Can everyone read this? Is this big enough? They turn to what are called the ancient writers. Okay, who are these ancient writers? Again, these were these philosophers who wrote these lengthy books on law. And before we had like cars, the internet, hunting was actually a big thing, right? This was a dispute that came up fairly often. So there were a surprising number of people who had written articles and books and treatises on how it works. Okay. So first we have Justinian and Fleta. And what's the principle that they give? Okay, it says, pursuit alone vests no property or right in the huntsman. Let's just stop there. That probably confused the heck out of you, just those few words. What that means is pursuing an animal, chasing it, is not enough to give the hunter property right. Pursuit is not enough. Go back next, okay. That even pursuit accompanied with wounding is equally ineffectual. Yes, what does that mean? Even if you're chasing the fox, right, and you throw a rock at it, and you wound it, so the fox is hurt, but it manages to get away, you're out of luck. Okay? Unless the animal be actually taken. So unless you can actually physically, and I actually have a stuffed fox, and I forgot it in my room, I'm annoyed. Right? So unless you can actually touch the fox, you lose. Okay? Here we have Pufendorf, right? Pufendorf defines beast fere naturae. Did anyone look that word up? Who looked it up? You? What does it mean? Good. Does everyone know what Black's Law Dictionary is? That's your new best friend. Yeah, that's your new best friend. Anyone have a copy of it, or you don't need to buy a copy of it because you'll have it online in Westlaw. Have they given you a Westlaw pass? Oh, she has a. Yeah. There's a little one you can have. So, did they give you your Westlaw password yet? No. You'll get those soon. Until you do, you go down to the library. It's easy enough. If you see a word that looks like it's in a foreign language, hint. If it's in italics, it's probably Latin. Hint. Not always, but usually. Look it up. You don't want to be in a situation where a professor says, Mr. So-and-so, what's fere naturae? Like, I don't know. And they'll say, did you look it up? And you say, no. And he's like, why not? It's like, I don't know. Okay, so now I'm telling you, if there's a word that you don't know, take 5 seconds, look it up in the dictionary, and in your notes, write down what that word means. Okay? Good? All right. Because they use this word like 4 or 5 times in the opinion. All right, so Pufendorf was this other guy, and he said that occupancy or possession of these wild animals is the actual corporal possession, right? You ever have like corporal punishment? That means bodily, right, to your body. So to capture a wild animal, you need to actually possess the body, right? Corpus Christi, right? You need to have the body yourself, right? Corpus Christi means the body of Christ, the city, right? Okay. Okay, and Binkershock, a funny name, coinciding, he agrees, okay? Okay, what else? Okay, but Pufendorf also writes, a wild beast who's mortally wounded or maimed, which means one of their legs is destroyed, can't be intercepted by another while the pursuit is ongoing. So what does this mean? If the hunter mortally wounds the animal, say like he strikes him in the leg and breaks his leg, at that point, the jerk can't come in and swoop and take him. Okay. So this is probably the holding, and pretty close to what he said. Mere pursuit just chasing the fox, right, gave the hunter no legal right. He became the property of Pearson, the jerk, because he intercepted him, actually captured him. Right? If you want to be really fancy, right, you can just read that sentence. That's basically the holding. It's in there usually. You have to find it. Okay? All right, so then they talk about all the stuff about the decisions of England, and I mentioned that at the time they weren't relying on English statutes, so it's not really binding, okay? All right, but now things aren't as clear as they would lead you to believe, right? Okay, so it says Barbarack, blah, 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 says that actual body seizure is not always necessary. Okay. Now this goes to a lengthy discussion, which I don't really care enough to explain to you now. You'll do it in property. But there's a different school of thought, right? If you're the hunter and you're investing all this time and energy into the hunt, you've done something. And don't we as society want to reward people who invest labor, right? Because think about it this way. If you're a hunter and the law is now that a jerk can come steal your fox at the last minute, do you bother hunting anymore? Do you bother getting all the hounds and doing all these trappings? Do you bother investing all this energy and labor into this pursuit when some jerk can come and swipe at the last minute? Maybe not. So there's other school of thought that says maybe we should actually give a property right in the fox because someone invests all this labor. If anyone say John Locke at any point in their legal career, you'll know that John Locke was in favor of labor theory, where if you invest labor into a task, you can actually get something for it. Where if you do everything but touch the animal, right? Like the fox is there, right? And you're about to grab him, and then someone swipes him. You've done a lot of work. You've done all the work getting there. Okay. So the rest of the opinion from the majority tries to reconcile these different writers. Okay. Or any other questions in the majority opinion? You'll do this in property. I'm not so much concerned if you know the law. That's almost immaterial for today. You'll forget it by January anyway. So the dissent, though, is perhaps included in every book because it's such. I don't know if you could tell, but the guy was being a jerk himself. He was being very snarky, right? Everyone know what snark means? Everyone know what it stands for? Oh, snide remark. Yeah. Snark means snide remark. So it's a new word. Do you know that the Oxford Dictionary added YOLO to the dictionary? I read that this morning. Our language is developing. Don't use that in class. Don't hold the dictionary. Brian Garner has not added to Black's dictionary yet. It will not be added. Although there is a plea of YOLO contandre if you want to really. I'll leave that there. Okay. All right. So the dissent makes this point, which I think, if any of you are hunters, would probably make the most sense. Why the heck is this in court, right? Anyone here a hunter? Do you ever have a dispute like this, or people fighting over an animal? Well, how would you resolve this? What do you think?
Texas has laws against or dealing with it actually.
Yeah, but before you go to a court or a game marshal, how do you think two people would resolve this?
I mean, I've never had a dispute like that, so.
Do you think this would be taken to court?
Yeah, you mostly just settle it amongst yourselves.
Buy them a beer or something and move on with it?
I mean, it's just kind of like, hey, my bad, dude. Sorry about that.
Yes, right. Well, and that's basically the point made. It's like, listen, this is a dispute that should be submitted to the sportsmen, right? The hunters, right? Why is this dispute even an issue in our court system? Why are we wasting our freaking time on deciding this foxes, right? Why are we looking at all these Roman and Latin and garbage things, right? He says the sportsmen would have had no difficulty coming to the correct conclusion, right? They would have figured it out amongst themselves, and that's fine. But the parties have referred this question to our judgment, right? They brought it here, and we're judges, so we have to act like judges, and we have to find some way of deciding this case. We got to do something, right? Either the hunter or the jerk's got to win. They can't both win. I mean, I guess you could cut the fox in half, you could Solomon it, but that's not what they do here. So most of the dissent analysis is basically being a jerk and saying that all these rules were written hundreds of years ago in a different time with different circumstances, right? When these laws are written, the policy was you want to kill as many foxes as possible because foxes like eat chickens, right? They're bad. But today, the culture is different. Today, the cultures have these elaborate fox hunts where the goal isn't to exterminate the foxes. The goal is to actually engage in the sport of hunting, right? So at the very end, he says, you know, we were without any municipal regulations. We have no statutes, right? So what should we do? Well, I'm going to go with Barbrack and make this the rule. Okay? So if anyone asks you what was the rule of the dissent, which I didn't ask you, but it would basically be this. Property in wild animals may be required without bodily touch, without touching the animal, if the hunter's within reach. So if, like, you know, the hunter's a few feet away, he's almost there, give it to the hunter. Or what if the hunter has a reasonable prospect of taking it? I mean, he's running and he's going to get it, you know, in a few seconds. Okay? He has thus discovered an intention of converting to his own use. So he's a few feet away from the fox. He says, "I'm going to get you." He has his, you know, his knife ready to kill it, and then the jerk swoops in at the last minute. For the dissent, that's enough to give the fox to the hunter. He's done enough work. He's cornered it. He's put it into the you know, into the woods. That's enough. Okay, so he says, the justice's judgment. That's that Queen's Court, right? The court in Queens, the King of Queens, whatever, right? It should be affirmed. Alas, he's in the dissent. Okay. All right. Questions?
Quick question on that.
Yes.
They become part of precedent, or is it?
No. You don't cite dissents. Okay. I promise you, you'll be doing your legal research project this year. Oh, damn it, this dissent's so good for me. No. It's a dissent for a reason. It's not the law. Okay? Now, why do judges write dissents? Well, sometimes they think it's important to point out errors in the majority. Sometimes they think that maybe one day their dissent will become a majority opinion if the court changes. So dissents play an important role, but don't cite dissents. Okay. Other questions? Other questions? All right. Yes, sir.
Was this on public land or something? Or
Yes, it was on a public beach. Okay, so if you really want to be detailed, there's a discussion of a phrase, which I hope some of you might have looked up, ratione soli. What does that mean?
Landowner.
Landowner, yes. So there's a doctrine where, and this should surprise people in Texas, if you go hunting on someone else's land and you kill an animal, you don't get to keep it. Animals on a piece of land presumably belong to the landowner. This happened on a public beach. But yeah, there was discussion of the duck decoys and the ratione soli. That's actually ownership of land. Other questions? All right, so what I'm going to do is I'm going to take out this cake, and I'm going to sit around. You can ask me questions, do whatever you want. But this is my birthday cake. It's really good. It's from Phoenicia. And I got bowls, and I got plates. So try to be orderly and not too chaotic. Come up and take it. I think you enjoy it. But thank you so much. I appreciate it.
Thank you.
Thank you.
Happy birthday.
I know.
All right. Here. Yeah, it's not sliced. I think it'll manage. If anyone wants to go ahead and slice, that'd be good. It's good cake.